there's a lack of information on what human rights are all about. So generally, for 10 to 12 years, you have to be very simple in how you deal with it. So after an initial role play about human rights, I normally tell them that there are 3 elements that are indispensable for a right to become real, generally speaking. There may be exceptions, but generally speaking, that is legislation, implementation, which is following it up on the ground, and access to justice. And it is about this access to justice that I think we're going to focus in this panel, which is described as deliberating on the losses and gains of moving the right to education from directive principles to fundamental rights, and thus making judicial intervention a key strategy in realizing the right. The possibilities of non-adversarial strategies, whether in courts or outside, shall also be explored. And why I've read out these 2 sentences to you, it's because I think it encapsulates exactly what we will be doing in this panel. Look at the judicial remedies and look at the non-judicial remedies. I will not refer to the impressive CVs of my colleagues. I just picked out one of their hats, which to me is like a guarantee that we will have a multidisciplinary exchange. Amita is perhaps what I would like to highlight here is that she's the driving force behind this project. Ashok is a practicing advocate. Amita is a social scientist. And Niranjan is a program head for protection of child rights. So this is my choice of your different hats, because I think that's going to really provide us with this multidisciplinary, transdisciplinary, multi-discussed approach that we've been having since the beginning of this conference. I will try to follow up on the steps of the previous chairs who have been extremely efficient with their use of time. And I would please ask you also to bear with me when we need to take a stronger stand, which I hope we will not. So I will give the floor to Amita. I think she's the first speaker of the panel. Amita, please.
Good afternoon. One of the things that we have been talking about in this conference or this conversation, or something we've been conversing about on a very constant kind of basis, is that if we speak in terms of rights, and if you talk in a common law country, this business of there being a right only if there is a remedy, and remedies being seen very much like you're being able to move courts. So I thought it was important as we start this discussion around the right to education to closely look at what I have titled, what was put out as the session title as the crisis of justiciability, but I've taken a more, you could say, a more instrumental kind of understanding, and I'm sort of saying, how do we understand justiciability, or how should we use justiciability? It's like, okay, it is one way in which people look at rights, but it's important that we should say that this right-remedy connection should it be such an inextricable one? That's the point that we need to make. I start out by literally trying to, in a very basic building blocks basis, because we are a transdisciplinary audience, I'm doing something like going back to basic building blocks and saying, how do we understand justiciability? What would you put in there? So for me, there's this business of, one of it is that the right to move courts. And you need to be sort of, an issue is justiciable or a right is justiciable if you can go to court when you are denied it or you're deprived of that right. So that's a very critical component. So the moment you do that, then the court sort of becomes the arbiter between the claim of the citizen and the state. Largely, when we speak in terms of rights, there is the entire conception of horizontal rights, and increasingly, even in the realm of education, we do talk about it, but I'm taking the more vertical line here and saying the whole business of justiciability much more comes there. If you do justiciability even between citizens and citizens, the only thing is that that then becomes is that the courts should recognize that, yes, they can be arbiters when one citizen denies it to the other. The most underlying premise is this, that when you talk about justiciability, and you say that a right is a right, if you have a remedy, you are presuming that people can go to court. You can access courts. Courts generally work on a reactive basis, which means somebody goes to them, then they act. Nowadays, they have started on a bit of a suo motu thing, but I'll come to that in a minute. But traditionally, and you understand it as that, yes, you say it is justiciable, you can go to court and ask for a remedy. The next significant thing in the basic building blocks thing would be the whole issue of locus standi. You say you can go to court if you are the aggrieved person. It's only the aggrieved person who can move court. Connect that with that last sentence I had in the previous slide when I was saying that, yes, justiciability presumes that you can access courts. So similarly, if we say that I can access only the person who's aggrieved can access courts or can move the court, then necessarily people who are economically, socially, educationally disadvantaged are not the people who really can be asserting their rights, even if those rights have been recognized. And that's the significance of this whole liberalization of locus standi. Unfortunately for us, this liberalization of locus standi has become that everybody requires somebody else to be going to court for them. But that is not how the entire thing was conceptualized. It was conceptualized as only liberalizing for those who could not on their own be able to do it, and to bring the matter to the notice of the court and for then things to move on. So it's a pretty critical thing, this whole question of liberalization. The only thing which we also need to understand is liberalization was to the fact that the matter goes to court. It doesn't then mean that the person who takes it to court becomes the forever surrogate of the individual or for the group for whom she has taken the matter to court. This was the kind of jurisprudence which should have come from the court. Unfortunately, what we landed up having is like nobody at all was capable of moving the court themselves. So whether you are a Kapil Dev or you are, like irrespective of how high you are in the social echelon or the judges themselves, somebody else is moving the court for you. And I think that's the fundamental distinction which Professor Bakshi very cryptically says, that it should be called social action litigation. It is not a terminological difference. It is a substantive difference whether you call it social action or you call it public interest. When you call it public interest can cover the world at large, but social action only covers disadvantaged people, and the liberalization of locus standi was basically for that constituency, and that's the distinction we somewhere lost out. So when people say public interest litigation, which Professor Bakshi calls social action litigation, I think it's not a terminological issue. It's not a jargon issue. It is a substantive conceptual issue, and it should be understood that way. I mean, it's like, if words are weapons, and I'm quoting you, if words are weapons, then I feel how we describe this liberalization of locus standi is extremely important in what you can do with it and what you can't do with it. Who is it for whom locus standi should be liberalized, must be liberalized, and who it is for whom it should not be? If they don't wish to sort of agitate for their own rights in courts, then they lump it, because they have the wherewithal. I just want to put this as a background. Next slide, please. The point that I want you to sort of next appreciate is, what does all this mean in the context of the right to education? It's just a very quick kind of, right to education came in the constitution of the country. If you look at the Constituent Assembly debate, it firstly came as a fundamental right. It was in subsequent discussion that it was then transferred to directive principles, because people felt we would not have the resources. The entire thing would get clogged by people continually going to move continually moving the court on that ground, and that is problematic. So then it came as a directive principle, and it's important for us to understand this, shall not be enforced by the court. It doesn't mean shall not be enforced. It shall not be enforced by the court, but it's fundamental in the governance of the country. And that's a very, again, if we really want to read carefully the kind of language of the Constitution, it nowhere is saying that because it's a directive principle and will not be enforced by courts, doesn't mean it will not be enforced. It's a different thing because we were supposed to get universal and free education for everybody within 10 years of the Constitution. That was the promise. We were not able to do that. And as time passed, the dissatisfaction started to climb up till people felt that, oh, if we were to just make this into a fundamental right, we'll have it all sorted. We'll have it in the sense of the moment judicial enforceability comes to back this entire enterprise of making it a right, we would be, next slide, we would be like better off. So we sort of had the constitutional amendment, we sort of decided that, okay, it took us a fair amount of time after the constitutional amendment to get the statute. But what I want you to note is that the moment we moved from making it from it being a directive principle to it being a fundamental right, what we landed up doing is we first of all curtailed it. We believe that, oh God, if it's going to be a fundamental right, then it's not up to 14 years, it's from 6 to 14. We all know anybody who has any kind of understanding of education, we have a messiahs actually, of the early childhood education in the house, and they would be speaking tomorrow. But the point somewhere is this, I'm talking about both Devika and Mridula there. So it's like from that if you do not do what is to happen from 0 to 6, you're not really going to be doing anything from 6 to 14. So in effect, that was like one loss we made in making that transference. The other thing is what has to be understood is it was a fundamental right as Parliament will determine by law. So the Constitution itself was not really doing much. It was going to be, see, one of the critical things of making something a fundamental right is to say that if this kinds of, you make anything, any law which is an infringement of that fundamental right is going to be to that extent be void. So anything which is anti-education, which is going to be, where your whole range of child labor statutes could become questionable, anything in any which way which is preventing people from obtaining that education would become bad, but that's not what we did. We said it is as by law determined, so that was the other kind of major thing. I only want to stress on this is that the moment we went this route of making it justiciable, and this is resonating with the kind of point that Anandita was making when she was talking about the right to housing, that the asking for judicial enforcement gets legislatures and executives on this kind of mode where they start to curtail rather than, it's like giving less rather than giving more. We believe this is a way by which we can eke out better. And the presumption behind that is that the courts will stand with us, that the courts will be kind of doing what we want from them. So who? And I've sort of very quickly, because I, having kind of been the time terrorist for everybody, I have to be for myself too. So I'm just sort of saying this, that, okay, logically, when you have a right coming in, you have the constituency for whom the right has been recognized. You have a target group if you're changing any kind of entitlements, which means that something they could do before this came, they cannot anymore do, so you're changing things for them. And you have the collateral group, which is like the set of people who have to do things to be making the right actualized. I did a kind of all the litigation which has come, necessarily appellate court litigation, but all the litigation which has come under the Right to Education Act, and what you'll end up finding there is that the smallest percentage of litigation is the litigation which has come from the constituency. The largest is what is coming in from the collateral group, and the other middle portion, which is relatively much more, is the target group. That is the schools going there and saying 25% kyun bole ho, hum nahi de sakte, and all of that, and that kind of litigation. The ones who are saying that, okay, where are the schools and where are the teachers? Very little. Where you're asking for no detention, or you're saying that first class means from the beginning and it should be across the board for all of those 8 years, no go. So if you look at that, then one starts to wonder, what is it that we're gaining from? The other thing next slide, the next thing I want to just sort of point out to you, and that is extremely significant in terms of making it a legal right and doing, then there are a range of authorities which have come in, whether it's a school management committee, whether what you have done in relation to panchayats. So you have a way by which you can run the statute, mediate it through them. The sort of presentation we got from Arvind Singh was saying something, and when Niranjan speaks, he will speak much more on this. I'm just flagging this out as a non-adversarial way of getting that act to function. Next slide, please. So, because this is a question that gets asked the moment you start asking questions around justiciability. Should we oust courts? No, I'm not saying they should oust courts. What I am saying is adjudication as such is an all and nothing game. So when you go to court to enforce rights, you're not particularly sure that what you want from them is what they give you. If they are on the same page as you, wow. It's a sort of point which Professor Bakshi was making, that when Desai and all were doing that labor law jurisprudence, we said, wah wah. When the other thing happened, then we had a difficulty. Because when the court is on the same side as us, we like the court. When they're not with us, then we have problem with this. But it's inherent in the way in which you understand adjudication. Similarly, judges believe they have to be these neutral arbiters. And of course, they consider themselves by default learned, which one has another kind of difficulty. Learned in the sense that when you're talking in terms of education, when you talk in terms of a no detention policy, when you speak in terms of special education for people with disabilities, or inclusive education for people with disabilities, you have a Deepak Mishra saying, how can people with disabilities be sitting in the same school as a person who's non-disabled? It's impossible because you don't know. But you're a learned judge. So we have difficulties of that kind. I would sort of just conclude by what I think is our take. And I'm hoping that in the following discussion there would be more. It's just to say justiciability is not a universal panacea. It's not like you get justiciability and you get education. It doesn't work like that. It is a double-edged sword. There are things which courts can do and there are things which courts cannot do. But they think they can do everything. So you have to be very careful as to when you go to them for that which they can do and not for that which they cannot do. And expand your repertoire of enforcement, create a culture of observance, and on all the time basis, keep renewing this relationship between law and justice. Getting a legislation one time is not, it's not the end, it's the beginning of the conversation. Thank you so much.
Thank you very much, Amit, and thank you also for keeping to the time. I would have a difficult task, of course, but
Really enjoyed it.
But I think there were a couple of issues that you brought up and that I'm sure will get picked up in the dialogue. But there's one thing which particularly appeals to me, and this is the difference between social action and public interest. And I had not heard this term social action before, but I think there's a lot going for it. Social action litigation? No, I had not heard. Social action is something else, but litigation, social action. Class action, yes. Public interest, yes.
Litigation is not class action.
Whatever, but class action I'd heard of. Yes. Public interest also. Social action litigation I had not. And I'd be very glad to.
It is the Indian jurisprudence.
Very well. But I also want to pick up on something you said. Courts can do certain things and courts cannot do certain things. But I would add that there are some things that only courts can do. So, and I think that will also provide some food for thought. I will now move on to Ashok. Ashok whispered to me that he would look at the justiciability issue, but in terms of the right to health. And I think that's a good option, because justiciability really is something that is underlines all the socioeconomic rights. So if you can take up the right to health, I think it would also be useful. Thank you.
Friends, whenever we fight for or claim socio-economic rights, the crisis of justiciability will come. But how to overcome it, that is I think, the art also. I would like to share, if time permits, 3 cases. One relates to right to housing, another right to health, and third one is right to education. Right to housing, I will share with you. In 1999-2000, during that period, in Delhi, around 1 lakh shanties were demolished and 5 lakh population was relocated at the outskirts of Delhi, which was around 26 kilometers from the center. And when I visited some of the areas where they were to be relocated, I found there is nothing, no water, nothing, no development. I talked to the urban development, that is called Slum Department Chief, Mr. Manjeet Singh, and I talked to him. There is nothing, why you are sending them to them? He told me that, Mr. Agarwal, when these people came to Delhi and settled there, there was nothing. So they will create themselves. What is this? I saw children studying, there are no schools. Then I filed a petition in 1999 and in High Court, and that went for around two years or so. And a lot of orders were passed. And almost on every hearing, a lot of high-ups of central government, Delhi government, this and that, all were used to be present in court about construction of roads, about schools, about water facility, all sorts of even transport, wherever it is not available, High Court passed orders. So a lot of things happened because of court's intervention. Otherwise, I think only God can help them. The another case which is I want to share with you is about right to health, and a very interesting and very, I think, informative and innovative, something impossible made possible, is a case of rare disease that is called Gaucher disease. It needs a very high cost. Fatality is very high. So what happened in 2013, one person who was a rickshaw puller, his four children already died of this disease. He tried to take help of the government hospitals, no help because it was a high cost. Then the last one, 5th child, Muhammad Ahmad, he was taking treatment under AIIMS, All India Institute of Medical Sciences, and AIIMS gave him his estimate of medical cost, that is 4.80 per month for lifelong. This certificate was given to him, and somebody told him, please go to Prime Minister office, he will give you. He went to the office of Prime Minister, he said, Pagal ho gaya, are you mad? This money, how we can give you? And he was weeping, crying outside the Prime Minister office, and then some journalist saw him and then talked to him, and journalist gave my telephone number. This is how that rickshaw puller, Sirajuddin, came to my office. And when I saw this certificate, I also thought how it is possible. We don't have a right to health as a fundamental right. We have no legislation. It is all depends upon the whims and fancies of the government. Then I talked to one very high reputed hospital doctors about that. And that said, Mr. Agarwal, life quality is not good. It is painful also. And cost is very high. So at one point of time, I surrendered this idea. But meanwhile, what had happened, that the father got 4.80 lakh rupee from Delhi government because they have some scheme to pay up to 5 lakh for life-threatening disease. And because of that payment, the child got a treatment, 1 month treatment. And after 1 month, AIMS asked, bring more money. Money is finished. And during that treatment of 1 month, the child got additional weight of 1 kg. This is a recovery signs. He went to the government said we can only give you 20,000, left out money. The treatment was stopped. Then he came to me. Then I thought, either do or don't do. Take a decision. Then I said, all right, I will do. I will move a petition in the High Court and let us see. And then matter came before a judge. And judge was, I can say, human judge, means human right. And he first got collected 13, 14 lakhs amongst the lawyers, from the lawyers, and 2 months treatment went on. Then one month treatment was given with Vedanta. Then 3 months treatment was given by a foreign drug company. This is how litigation periods of 6 months passed. And then ultimately High Court passed an order saying that he has a right. We can't allow a child to die when the treatment is available and money is hardly matters. And they directed government of Delhi to pay regularly this whatever amount he requires. That's a different thing because meanwhile some foreign drug company adopted the child and there was no need to ask government, but they went to the division bench in appeal and appeal got them their statement recorded that we will continue treatment. And High Court also passed some directions about to the government to make a comprehensive policy about that to address this. Then now, a few months back, the central government has made a policy, national policy for treatment of rare diseases. This is one part of the story, and the child is hale and hearty, and now some producer in Bombay is going to make a film on that. The more interesting part is because of this, what happened in Employees State Insurance Corporation. Employees Insurance Corporation, you know, there are 2 crore insured persons with Employees State Insurance, and 8 crores are the beneficiaries, family members. So many children of the employees are also suffering from this Gaucher disease. They also came to me from Karnataka, Tamil Nadu, Maharashtra, Delhi, and I filed a petition and saying that because it is not free, ESI is, I am contributing, this is my money. They don't get any, ESI don't get any money from any other source except employer and employee. I said, it is your obligation. So what they did, they floated the guidelines saying that they can only spend up to 10 lakh per beneficiary per year, not more than, they put a cap on that. And they also said if the child is born before the registration with the ESIC, they are not liable. So I challenged both the clauses in the High Court. High Court by an interim order directing them to provide the treatment. And at present, at least 13 to 14 children in different parts of the country are taking treatment through ESIC, and ESIC spending 13-14 crore a year on these 13-14 children. Another case, this is how we can articulate things. The last one is about, I can say, private schools and 25%. Because many of people sitting here may not be knowing that how this provision came in the Right to Education Act. Right to Education Act has, okay, sufficient time. Right to Education Act has come only in 2009 and enforceable from 1st April 2010. So what has happened, I was fighting a case about fee hike in Delhi High Court. In 1997, I raised, this was the first case in country where parents went to the High Court saying arbitrary fee is charged by the private school and it tantamount to commercialization, which Unikrishnan case says you can't do it. Then, many times during that hearing of the case, it came up, you have a government land, you have a condition, why you are not providing free treatment. Somehow, I got a list of 265 societies because land was allotted to societies. And I can give you one example of how, about land, that like 6 acres is given to a school, to a society for school. 4 acres are for 5,000 rupees per acre, means 20,000. And 2 acres for playground is only for 1 rupee, means 20,001, 6 acre school with the 6 acres land with the condition that you will provide to the extent of 25% admission to children belonging to weaker section and grant them free shift. But it was never happening. Many times in the parliament also, in the assembly, Delhi assembly also, questions were raised, going on. But the moment I got that list, 265 societies, I filed a case in 2002 in Delhi High Court, saying that they are obliged to provide this. One more interesting thing, that at the one time I was fighting against fee hike. On the other, I was thinking of filing a case for 25%. I came across something like this, that suppose if burden goes on the parents, what will happen? Then I talked to some parents. I talked to them that I want to file this case. What do you say? They say the private schools are already charging on account of these children. And in any case, you fight it. If occasion will arise where we have to pay, we will pay, but the fight against private school must go on. So I got encouraged by that. And then 20th January 2004, Right to Education Act has come after 6-7 years. The High Court passed the first order, directing Director of Education to ensure compliance of this, and whosoever school is not following it, you take action against them. It means that you send their names to the landowning agency and they will take action against them. And we wanted to execute this order in 2004-2005 itself. The government was avoiding it. Government is always, normally all governments are in collusion with all these private schools. So they were not going to. Then we filed an application. That, because the difficulty was that you know the names of the society, but you don't know the names of the schools being established by them. So we asked the High Court that please direct them to tell us which are the schools. And then on 27th of April 2004, High Court directed Government of Delhi to publish the list within 1 week. Then after a week, I think 2-3 full pages of all leading newspapers carried. That is how it all started. And because of this experience, successful experience in Delhi, this provision was incorporated in the Right to Education Act for all children about unaided private schools, non-minority unaided private schools. Thank you.
Thank you very much, Ashok. I think I would only perhaps signal the right to health case because it was a successful case. We may even have a film, so it's really successful and it will be publicized. But I just wanted to give back to the audience something you said. How can I do this? Health is not even a fundamental right. So what I understood from that is that if it was a fundamental right, you would have had a different procedure. And I just want to make sure that that is the case because that ties with what Amita was saying about how the right to education was curtailed after it became a fundamental right. Now I will give the floor to Amita. Anita, please.
Afternoon, friends. I do want to say that despite the technicalities and the problems about justiciability, which the lawyers can deal with, we working in education have really found, I find it very reassuring to be here with such a large collection of humanist legal minds. But we are really, the last resort right now for us is trying to get justice from the courts. And education is under an assault from all kinds of quarters, from a right-wing agenda, from neoliberal economists. In fact, educationists are nowhere in the picture of policy making now, currently, and also corporate managerial discourses and strategies. So I'll share with you what hope we had and we still have, despite the problems, with the Right to Education Act and why certain things were put in as justiciable and what was the thinking and deliberation around that. These are some of the things that we've learned. Internationally, people in education have learned what education does do and what kind of education, how does it help, what is the experience of school in terms of shaping perceptions about a fair and equitable society. How does socially inclusive schooling help? What does it shape? And also the earlier models of the 50s when it was thought, like Singapore and many other countries, where it was thought that you can segregate early according to people's potential and their abilities and then develop schools of excellence, whether it's for sports or it's for academics, and then that is an efficient model, has now been given up. I mean, now we are not talking the discourse, especially the progressive humanist discourse is not on efficiency, it's clearly on equity. And so I do want to remember that before us. So I think I should get my laptop here. So just giving you a background to this act, as briefly was given by Amita, but it was a very long struggle. And contrary to what friend Neera was saying on the first day, which I also found problematic, it was really a struggle which was, since the 90s that I can remember, very large groups of organizations, whatever we may call them, voluntary groups, human rights groups, civil society organizations. And also a part of it was in the literacy campaign, which we think was a true abhiyan, a true campaign, and what came later was only borrowing the name with not its spirit, which was the Sarva Shiksha Abhiyan, which was a call for education for all and was related to this declaration of World Education for All. The probe study, which was steered by Jean Drèze, and I was part of that study, was also a part of this campaign, was also a part of trying to bring out a public report on basic education and to debunk certain myths about, which was still there in education policy making, that, it's more important, children's wages are more important, the poor don't want them to go into school. And also, there was a widening quality chasm, a divide in Sarva Shiksha, and the government was compromising on quality. The government was creating segregated schools, poor schools for poor people, and Kendriya Vidyalayas and Navodaya Vidyalayas, very well-resourced government schools for those who were in the middle class. And also we saw how half our children were being pushed out of school. So it was not dropout, it was being pushed out of the school before they completed elementary school. So that was the status. And also because when people came into a very participatory literacy campaign, they said if we can come, because the literacy campaign was based on a critical model of understanding education and literacy and inspired by Freire. And they said, if we can come into school and we can learn at this age, why can't our children get good quality education? So you'll notice that RTE kept talking about quality education because that became equitable quality education, because that has what was being compromised completely by the state, which ran, even states which could afford, like Maharashtra, Karnataka, went into para teachers, contractual teachers, untrained teachers, because the central funds were coming for that. So this was, and West Bengal went into women para teachers with all fancy names, Sahayika, Shiksha Mitra, etc. So all you know, very fancy names, but women para teachers age 40 and above. So at one of the meetings when I was doing a study and I asked them, I said, why this age? I mean, it was clear why it was women age 40, but I just asked the organizers, the bureaucrats, and they said, you know, we're looking for motherly qualities. So I said, well, then you should go for higher ages for grandmotherly qualities. You know, that may be better for the school system. So, I mean, these were the kinds of discourses which are happening under Sarva Shiksha Abhiyan. So this is what really galvanized people from all different quarters to fight for this and say that this is, and economically the country was doing very well. So I remember with Ashok ji and Vinod, we once went and even met the Prime Minister at one of the crucial stages when they were trying to, you know, after the amendment came in 2002, and the BJP government, the NDA government brought out a dismal draft of the RTE. And again, this galvanized people, because it brought in everything, all kinds of alternative provisions, cheap provisions, everything was brought in under right to education and accepted. So again, the movement got galvanized, and then at last in 2009, it was passed, and 2010, it was implemented. Implementation started. So even that was a very long struggle. Some of the things, like I've written in that the RTE bans selective or any screening of a child till age 14, and there are no board exams. Now, these are very crucial things, and I'll briefly share why. One, of course, that the world over we find that competitive tests, the more competitive a test, it only tests your social advantage. It tests very little about the quality of learning and quality of education. So the correlation tells us that competitive tests, more centralized tests, the more distant they are from the location and the site of learning, the more they do damage to what you're actually fighting for. And also that measures of progress of a child, progress of learning, are much less susceptible than to competitive tests as far as the background of the child is concerned. The MHRD note, and MHRD gave a rationale, and that was a time when I know we had an MHRD which was really sensitive to listening and to open to these ideas. We were sharing all that we knew of experience from the ground. I'm part of Bharat Gyan Vigyan Samiti, which is a large organization nationally in different states. I was also involved with the literacy campaigns and many other groups. So we were every time they'd say, okay, what does research tell us about grade retention? What happens in terms of detention? What happens in terms of board exams? And we'd share evidence and research, whatever was available. So the MHRD for section 16 gave this note. And what is curious is that now when in September, the MHRD has placed this section for amendment, it does quote 2 lines from here and says, yes, we know that exams demotivate, board exams will demotivate a child and not help, but our states are telling us that children are not learning, etc., etc. So there's no correlation between the rationale which now the government has given, even though it quotes from this rationale, which clearly says that you will not make a better child by failing a child. And it's the failure of the system. The MHRD itself gave this as a rationale. Don't punish the child, it's a failure of the system. Recognize that we have not provided an environment for learning, a congenial quality environment for learning. And that is exactly what has become most contentious. I know them. How will they learn? So this whole idea of fear being the only motivating factor, and the teachers say, I can't even scold this child, what am I doing? So that is something that needs much more. So this was just the section 16, and this is the amendment that has now been proposed last month. I really I come here looking for solidarity from all sectors of people around here. This has not yet been passed. It will be in the next parliament session, but I really think we need now a much larger campaign, both from the panchayats and also from all sort of legal support that we can get. The next slide, please. Now, these were the sections that were put in with a lot of thought why we were doing that. Despite that, even today, there is mental harassment, there is discrimination, and there is physical punishment. Though there is much less, people are wary, but there is that. And teachers are a very sad state. In fact, I'll come back on the last slide to say what is the current situation with teachers. I have to hurry up. So this was we look at it as a historic chapter in a Right to Education Act. And across countries, people working in education tell us that this is amazing that it's there in law, because nowhere do we have in law a whole chapter which says what kind of learning and what should be the assessment and how should the teaching be. So at least it's mandated. So for us, something there as a law in black and white is important, because when you talk about reforming practices within the school and within classroom, this we find to be very enabling, though implementation, of course, is something that you might understand better. But there are many things. For instance, if there is learning through activities and through exploration and through children learning how to express different views, today we know that not only that is not there. We know that children come into universities. I'm at Delhi University. Children come there and they can't even think for themselves. They are just doing a cut and paste job. They can neither write confidently in Hindi or English, being these two languages. The medium of instruction, those 4 words were added later as far as practicable. The original draft said it must be the first language of the child. These were added when it went around different ministries, including the law ministry. And making the child free of fear, trauma, and anxiety. I mean, this is today still the biggest challenge. Our exams, if you look at any school exam, it's amazing the kind of questions that are asked. So this right of the child has been violated each day since the year when this was implemented. The questions are meaningless, they're only memory-based, they're only asking for rote memory, and if you write with your own understanding, you get a 0, because the key answer said something else. So the next one, please. So what is happening? What are the state, I'm not talking of private schools right now, but what are the state systems? How are they acting with complete impunity? Something that immediately strikes us is Central Board for Secondary Education. Even its name tells us it has nothing to do with elementary education. It jumped on the bandwagon, and today it is dictating to the system how should comprehensive and continuous evaluation be done. It made a farce of it. It brought out manuals which showed no understanding of what is CCE. I was on the governing body when I was the dean of my faculty, tried to tell them that we'll help set up a team of people to work on it, but they were completely, this gave them control, and they have now fallen into, today I got a newspaper report given to me by someone who's working in RTE saying that now they are even deciding what primary assessment should be like, what should be the exam like for all CBSE schools. So how is this? They are not even mandated under the RTE. The mandated body is SCRT or NCRT. So how did they jump on? And they've been allowed to go on, wielding their power and completely off the track. So that has become a contention, because we didn't do learning assessments the way they were mandated to be. the whole act is now being made toothless by trying to push out this thing. Yesterday, I get a call from Chhattisgarh saying they're going to make a board exam for class 5. So everyday states, even though the act has still not been amended, but states have been flouting it. So no investment, contractual teachers, I did say no investment in teacher education ever for the last 10 years or more. And 90% of teacher training institutes are in the private sector and they are in an abysmal state. Rajasthan and Delhi government, they asked for detaining children from class 3. The first thing that the Delhi government, which was ostensibly an Aam Aadmi, a common person government, it came and it asked for detention in class 3. And Delhi government is doing the most discriminatory practice today in schools. It's segregating them. Till last year, it was doing in 6th, 7th, 8th, and 9th. Today, it's doing from class 1. It takes an absurd test. My student has done a PhD honors assessment she's submitting next week. But it takes an absurd test. On that basis, it gives you an ability grouping. It calls you either talented or it calls you committed. And those children in Nishtha know very well that they're considered no good. The teachers consider them no good. In many schools, they're given the most dilapidated classroom to sit in, the dirtiest space in the school. So they're being segregated and discriminated in every way by the system. In a class 1, you tell a child that you're no good, you can't read. That is a talented section. You know what you've done to them. Expectations determine performance. If teachers have low expectations of children, they can never be good learners. That's what all our theory tells us. And this is something which has been done even to failures. They've been called Vishwas group. We know that most of them failed in the last class 10 exam. Can you just raise this to the last point, please? What's more damaging is they're pushing children into vocational education. Right from class 3, age 8, the CABE committee has given a recommendation at age 8, offer children vocational education. Now we have a legacy of the Gandhian system, and in the national curriculum framework, we spoke about work and education, not vocational education, but work. The hand, head, and heart in education, what that means. We know it's transformative. Enough work in our own country has shown it as, but today they are trying to segregate and push out children, and we know which ones are being pushed out into skills. They don't have any knowledge, they only have skills, and knowledge is somewhere else. Thank you.
Thank you. I'm sure there will be questions in which you can then further develop some of these issues. But this concept of quality, I think, is very interesting. It resonates also with the work we do in the committee, because when you ask states about the quality issues, you will get questions like, first let us get universality. First let us make it compulsory. Then we will look at quality. Or first, let us have the sustained economic growth. Then we will look at social rights. And this permanent kind of, deferment that first we will get this, then we will get that, is really, in terms of quality, extremely damaging. Now I move on to our fourth panelist, Niranjana. You have the floor.
Yeah. Good afternoon. Respected chair and esteemed friends, I take this opportunity to profusely thank Amita and her team at NELSAR, particularly for two important reasons. Taking up this discussion on the socio-economic rights at this critical juncture, where the entire country feels talking about rights, asking about justiciability or social justice is a crime, and many a times people who are asking for that are, seen as anti-nationals. I think that's a very important juncture. Secondly, for a very important reason, bringing the whole diversified group, because I strongly believe any socio-economic and political or civil rights cannot be achieved unless we bring that kind of a synergy between various sectors, whether it is education, whether it is farmers, workers, women, children. I think that kind of a synergy which is really missing to make this as a political agenda in this country, and which is very, very important. So having said this, I just confine myself because already Amita and Anita made my work very easy because they have given some kind of a historical background of this right, and Anita thankfully has given some important provisions related to the right to education. So I don't want to get into those areas, but certainly one point in the beginning what Amita said, right to education in this country is always seen as something, kind of a very strong instrument for a political transformation. And at the same time, right to education is seen as a kind of a tool so that we can subjugate people so that the status quo is maintained. So that's the reason where, like Article 45, which was the only time-bound article in the Constitution. No other article except Article 45, which talks about 10 years of, kind of achieving the goal. But unfortunately, that was denied in the name of, it is just there in the directive principle, which is, non-justiciable. I think that is a crime, according to me. In fact, when studies was done, basically look at the deliberations of the Parliament for the first 10 years. Our great friend who is no more, late L.C. Jain, did a wonderful study of the first 10 years, what happened in the first 10 years to implement the constitutional aspirations. Because I strongly believe Indian Constitution is the product of the freedom struggle. It is a document, to collate the aspirations of the people. So when such, kind of route was taken for the first 10 years to understand the deliberations, L.C. Jain says, I quote, not even a single incident in the first 10 years to say that that article which was time-bound was discussed in the Parliament to achieve within the time framework. And L.C. Jain concludes his study saying, though right to education was fundamental to the Constitution, unfortunately it was not fundamental to our rulers. So I think probably it's a very important statement. So followed by that, of course, nearly for 42 years, just because it was in the directive principle, it was non-justiciable, and like people took, kind of very easy, kind of reason, not to give education to all children. And again, all of us need to remember the right to education in this country is not from the legislature, it is from the judiciary. Finally, in 1993, in the very famous case of Unnikrishnan versus State of Andhra Pradesh, and when people asked, many citizens approached the court to ask categorically the court whether in this country education is a fundamental right or not. Court said, it's a very interesting judgment, probably that's the reason I have a great respect for the judiciary, though there are serious, kind of lapses and all omissions, all these things, but just for this reason, court said a very wonderful, kind of a judgment, right to education flows from right to life. It's a very, 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 kind of far-reaching statement. Otherwise, all our understanding fundamental rights is different from, kind of directive principles. So I think that is where exactly the fundamental right emerged in this country. And again, if you look at the, kind of apathy as a kind of, the irresponsibility of the state, we took nearly 10 years to bring in 86th Constitutional Amendment to the, Constitution, 86th Constitutional Amendment Act to include right to education as a fundamental right. Again, there is a big politics. Big politics, the reason I call it as a big politics because all efforts was made. Every effort was made to dilute the judgment, pronounced by the Unnikrishnan case. If you look at, like I call it as, kind of all measures were taken to construct, design and construe to take away the justiciability, particularly for the children from 0 to 6 and, 15 to 18. What is this we are talking about? See, on one hand, Supreme Court says right to education is a fundamental right for all children from 0 to 14, where we have, kind of initiated a process to curtail it and just restrict it for, 6 to 14. I think this is a very serious, kind of a mischief by the legislature. I think we need to take these, note in a very different way, because I will certainly come to the, what should be the, kind of way forward. But again in 2002, when Constitution was amended, the very text of Article 21A, Amita has already mentioned about it. I don't know, there are many legal, luminaries here, particularly Bakshi. You have to tell us, I think this is the first country in the world which subjugate fundamental right into a kind of legislation. It says fundamental right will be given to children as the state may by law determine. So it was a fundamental right in the Constitution in 2002, the right came only in 2010. Look at the kind of delay. I call this as really the crisis. The really crisis in terms of, giving that, implementing the right to ensure, justiciability. I think this shows, the kind of, unwillingness, half-heartedness of the Indian state to provide, education to all children. So having said, finally, the act was, came into force. I don't know, like people say that it came, like all of us know that it came on 1st of April. It was basically to fool the people, April 1st. Because if you look at the next 7 years, now, the way it was implemented, if you look at the justiciability of this particular piece of legislation, justiciability for me is basically to take all necessary measures to implement this piece of legislation in a much more meaningful and effective manner. If you ask this question whether really state has taken any such measures on at least on important counts, like I think in my opinion, because I have taken a different route altogether for justiciability. I rely more on primary stakeholders, my people, rather than the courts. I have more faith in my people rather than the courts. I think court is the last resort. I think probably, I don't know whether I am right or wrong, but if you look at the entire thing, what kind of measures that we have taken in the last 7 years? The first thing is, whenever the legislation is enacted, we have to take massive, programs for awareness. Unfortunately, I just want to say, even today in the country, if you look at Section 9 of the RT Act, where the responsibility of implementing the legislation lies with the Panchayat Raj institutions, local authority, none of the Panchayat Raj members are aware about the Right to Education Act. That is the, scenario. And if you look at the, compliance, I am asking for minimum norms and standards. If you look at the schedule of the Right to Education Act, it talks about safe drinking water, 2 teachers. See, in this country, the biggest problem is we are not providing teachers or we are not providing classroom in accordance with the number of, classes or grades. Suppose if you have class from class 1 to class 5, instead of giving 5 classrooms, we give classrooms in terms of teachers. Suppose if there are 2 teachers, we give 2 classrooms. Those minimum norms, minimum classrooms, safe drinking water, access to, education, particularly for the children with, special needs. RTE forum, which is a very important and, a very big forum at the national level, says the compliance is about 8%. Out of 100 schools, only 8 schools are complied with this minimum 8 indicators, minimum 8 norms. How do we really, justify this? How do we really, and absolutely there is no roadmap so far. Whenever you enact a legislation, you have to have a roadmap. What you are going to do in the next 5 years, next 10 years, because this is an important piece of social legislation. And the importance was, displayed. Prime Minister on 1st of April addressed the nation about, the right to implementation of right to education. And if you look at the finance, which I see as an important, crucial component for, effective implementation and, to ensure a kind of justiciability, if you look at the figures, This is really, kind of something very worrisome. In 2013-14, the total allocation, the percentage of allocation in the budget was 4.57, whereas in 2017-18, it has come down to 3.71. It is less than, 4%. And if you take the overall GNP, I'm just talking about the average. If you take overall GNP, it is 0.63 in 2013-14, now it is 0.47. You are spending less than 1%. And are we talking about, kind of right to education, the justiciability? Where are we? I think this is a very, very serious, concern for all of us, because I don't know, in my understanding, right to education is fundamental for all other rights, whether it is housing right, land right, employment, social justice, equality. See, for me, the public education or the government schools are something like cradles, to protect our constitution. How can you protect the constitution unless you inculcate those constitutional values right from the beginning? But if you look at the entire scenario, the things are, really in a very bad shape. So therefore, the question of justiciability, particularly in terms of, looking at what kind of measures, what kind of institutional measures were created right from the school level, absolutely there is no mechanism for, to seek redressal. Suppose if there is no drinking water, there is no teacher, there is no, adequate teaching learning material, where children has to go? Where is the mechanism? Though Section 32 says local authority, so far in this country we have not created any redressal mechanism. Even the administrative redressal mechanism where children can go, this is not adequate enough. So how do we really, look at the justiciability part unless you create that kind of institution? So therefore, friends, what I have done, I have taken a different route. I have started mobilizing the primary stakeholders, particularly SMCs, right from school level to the state level. Particularly, empowering SMCs to, demand for the effective implementation of the Right to Education Act. And also, I think now probably the 2018, Karnataka is going for elections, and in a way we are thinking to make this as a political agenda. We say that in all 46,000 villages where SDMC is present, we will say we vote for people, we vote for education. I think that sort of a campaign is really called for at this moment. I think with this, I just want to re-emphasize that justiciability does not mean only approaching courts. There are various other mechanisms. And particularly mobilizing people is very, very important, because what I have realized and learned in my life, however may be the good may be the legislation, unless you mobilize people, it's very difficult, to implement the legislation. I just conclude my sharing with a quote, which is a very famous quote. I always love that quote from late V.R. Krishna Iyer, who was a former judge in the Supreme Court. I quote, "Law is an instrument. Justice is its function and its validation. If there is nothing to hope from the law," I just reiterate, if there is nothing to hope from the law, and if injustice is legalized, then insurrection will rise. With this, thank you very much. Thank you, Amita, for your wonderful work. We are completely with you. Probably all of us have to go hand in hand. I think the kind of inspiration I got in the last 3 days, I think probably will give much more, kind of energy for us to go back and say that we have a fundamental right that should be the given. Otherwise, we have all the energy to change the political transformation. Thank you very much.
Thank you very much. I think you've said it all with the last quote, but I just want to reaffirm what you said. The quote is not the only solution. It is a solution, it's not the only solution. I think that's what's come out from this panel. But I think it also has come out that justiciability is not only a crisis issue, it can also be a potential. And that is what I think we could begin by looking at. We have 20 minutes, more or less, right, Samita? Maybe 5 minutes extra, all right? So I would please ask you to be sharp, quick, focused, etc. Yes, David, I think your hand was first. I will take the three behind you, and then Professor Bakshi, I think you raised your hand, and then my
Two quick questions.
Yeah.
Thank you very much to the panel. First, to Amita, you said there are things that courts can do and there are things that the courts can't do. But I'd be interested to hear your conception of what they can and what they can't do, because that's the central question in socioeconomic rights litigation. What is it that the role of the courts? And I don't want to say too much, but briefly, many theorists are saying that the role of the court can be calibrated to the problem that needs to be addressed, whether it's incompetence, incapacity, intransigence. And the second quick question is to Professor Rampal. Just from the South African experience, what you have is children who, it's very hard to fail children, to keep children back. So children move up into the next phase, and they move up into the next phase, but they're not actually improving in their educational skills. So I wanted to understand what your proposal is for India, because to me it's not empowering children to move them into a class which they simply are unable to cope with.
Thank you. Geeta?
A quick question on the migrant children. The situation is, as far as Chennai is concerned, we have probably about, school-going age, there will be not less than 30,000 children, migrant children from Telangana, Andhra Pradesh, Orissa, and the Hindi belt, but really no school system. And the question of SSA that she was talking about actually is the only relevant schooling, because we want schooling in their mother tongue, So, and with great difficulty and with a lot of struggle and fight, we have got a few SSA centers only. And the ICDS is unwilling to get in and do childcare. So, we are really in a very difficult situation. So, you think this right is at all helpful? And of course, the other very important issue is this same thing applies to the displaced people. And thirdly, as far as census goes, there is nothing given in the law or the rules, I think, for the census. There is no, earlier on, even during the British days, they used to take the census of children. In each area, the corporation schools will have to take the census to ensure that all children go to school. But I don't think anything like that is happening. So,
thank you, Geeta. Walter?
While I agree with you that there should not be social discrimination, we also have to face the fact today we are living in a society where there is discrimination and a law has been passed and, as Rizwan said, has been imposed without any awareness building. So the same teachers who have rejected the weak have to teach these, and that is a major problem. Shouldn't we find an alternative of not just pushing that 25%, but forcing the government to ensure that everyone gets good education in other ways? With that finishing, question of exams. Again, I agree with you that competitive exam goes to the advantage of the more advantaged and the poor suffer. But then is the answer not having exams at all? Shouldn't we search for alternatives? Because I know many schools, the teachers have stopped teaching because there's no pressure on them to show results. So shouldn't we find an alternative of some sort of an exam which is not necessarily the competitive memory-based type. Isn't there an alternative?
Speak in two mics at once in the expectation that I can be more audible. I have two comments. I'll come to the difference between social action litigation and class action or public tomorrow. On the first comment is about right to education. Can you hear me? Yeah, okay. First is right to education. There was a very beautiful judgment by Allahabad High Court, a single judge last year, or year before last, which said the sons and daughters of the chief secretary and government people will have to go to the same municipal school if within 1 year his orders are not implemented. We had a convention in Allahabad, I could not go, to celebrate 1 year of the judgment. Now the judge had his second option of going in contempt, which most liberals do not like contempt power in courts. So shall we try and put our own priorities into some order? Should we not ask the courts to go to use their contempt jurisdiction liberally? Should we not give court more powers than they wish to have? That's the question for all of us. As to Amita, long time ago, Professor Hart said something very important in his concept of law. And Professor Hart said about Austin, that when he was wrong, he was clearly wrong. And that can be said about Professor Hart also. But he said that amazing thing about law is that if you take out the concept of sanctions, it is still intelligible. Intelligible. You can still make sense of the idea of law. So when you take out enforceability, you can still make sense of human rights, standards, and other norms, constitutional rights. But I want to come to the real question. The question is this. Time ago, Max Weber, a social theorist, talked about law in terms of jurisdiction. And the jurisdiction lies in expropriation of disputes. The courts expropriate individual disputes and expand jurisdiction. So when activists go, I was a part-time activist myself, I'm an NGI, you know, that without which there can't be NGOs. NGI stands for non-governmental individuals. And you are NGOs, non-governmental organizations, not-for-profit, whatever you call it. So, as an NGI, I am a quite active chap. I used to ask myself, I want to generalize the question, with that I'll stop. The question is, how far do we surrender our disputes to the court so the court may create new rights? How far are we prepared to go? We can't have it both ways. We can't have, on the one hand, judges helping us to decide certain norms which are progressive, and on the other hand, saying, we also stay in business. Judges ask you to implement the norms they create. That's the trade-off. That's the current trade-off. They will give you norms, and they will ask the NGOs, and you rightly said you will go marching in into the field. So what is the nature of trade-off? How do we, should the NGOs also be regarded as norm creators rather than implementers? Then the question is, who will implement the norms? So the question is, take out enforceability as a sine qua non of law, but who in everything that you hold dear is going to enforce the law?
As a non-lawyer, I am struck by can you hear? As a non-lawyer, I'm struck by a contradiction between two lines of argument that I'm getting. One is that more and more things should be justiciable in a court and enforceable by a court. The other is that I'm hearing of 10 to 20-year delays in implementing court decisions, with constant appeals, with a border between two tiny farms turning into a 20-year Jarndyce v. Jarndyce case with stay orders, both in the field of land law and in the field of housing law, leading to people not knowing where they stand and to the rights of the poor in law not being enforced. Do you want the law to do more, or do you want the law to do less? Should one rather go the path, which we've heard about this afternoon, of looking for negotiating ways of activism, pressuring, arbitrating ways of activism, and taking some of the strain off courts, which are obviously taking enormously long times even to deal with the material that they have already?
I have no comment, just an observation. You see, the idea that the Constituent Assembly had, that giving the education as a fundamental right would require resources that the state didn't have, is utter nonsense. Because you look at a much poorer country like Vietnam, or a much poorer country like China. China was much poorer than India in 1950. Both of them universalized elementary education and managed to get their people fully literate by about 1980s or so. In India's case, we still have the largest burden of illiterate people in the world. And the second point that Nehru didn't understand, he wanted to industrialize the country, but no country has become fully industrialized without universalizing education. It was done, first of all in Sweden, then following that in Japan, and then following that in Britain and other countries. It is only those countries which have fully become literate which have industrialized. And this is also true in countries like South Korea and Taiwan.
I'd like to just take on from where Professor Amia Bagchi ended, that right to education is a capitalist agenda, and it seems we don't have good capitalists in this country. So I would start with that. No, I'm saying right to education is necessary for capitalism. We are not talking about socialism. And we don't have good capitalists in the country, and therefore we don't have a right to education being implemented. We do not have enlightened elite in this country. We have people, we have their demand for education, and we know they're willing to fight the battles that he's fighting, the battles that BGV is fighting, the battle that everybody's fighting. The ground is ready. What is not ready is those who are supposed to be having their minds, and they just don't have it. They don't want to build capitalism in India. Now, this is the first thing. The second thing is that we did have, I think we should celebrate the fact that we have at least even this compromised right to education. You know, even that was a product of a huge battle. It didn't come up in the air just like that. And we knew how many of our colleagues and friends fought for even this. So let us not undermine what we have got as a compromise and use it. And in fact, it is a kind of a indication of at least this the state is willing to give. You know, in countries like ours, it sets the goals. The next set of battle is the implementation battle. So this is the second thing that I wanted to say. Just the last thing, I think after the thing was, right to education was enacted, at least know who our enemies are. And that is very important. You know, that who have contested children's right to education. The private schools have contested the right to education. The teachers' unions have contested right to education. The education department has contested right to education. The people who did not want to give investments in education, they're competing with children and their resources to build their So I out a list of all those who are enemies of children and their right to education and tell them that you fellows don't care for children, don't care for the country.
Many thanks to the panelists. I just want to pick up from what Professor Sinha said. The moment in 2002 when we got the constitutional amendment, I think it was really historic and gave a lot of hope to others who are struggling for justiciability and getting legal rights passed. But from 2002, from a fundamental right to education, which is supposed to be a universal right, what do you think, it's a question to the panel, went wrong and why did we get this targeted approach to education, right? From a universal fundamental right, what and how did it go wrong that we got to act only 6 to 14 years? We're interested to hear your reflections because it would really be of great learning value to the others struggling for similar rights.
Which I think everyone understands. I was given 5 minutes extra and I have like 5 hands up. Now, my choice, 6, 7 hands up. My choice is either I do not give you the floor, which I do not want to do, or I curtail the panelists. I have no other choice. So what would you prefer? So I will curtail the panelists? No, give the floor to the panelists. I am now reinforced my democratic decision. I will give the floor to the finalists. I will give you the floor maybe to one person, and then I will come back to the panelists. All right? You had your hand up for a long time. I'm sorry, but I cannot really... Please understand, it's very difficult, otherwise we'll go right into the break. Okay, quickly.
Yes. So this question is to Professor Anita. In your presentation, you mentioned something about punishment, corporal punishment of... Now the problem with corporal punishment is in the Right to Education Act, it bans corporal punishment, but RT is only for children from 6 to 14. What about children from 14 to 18? Another problem with it is Section 89 of the IPC actually kind of allows corporal punishment. I'll just read out in 10 seconds an excerpt from it. It says that nothing which is done in good faith for the benefit of a person under 12 years of age or unsound mind by consent either express or implied of the guardian or other person having lawful charge of the person is an offense by reason of any harm which it may cause or to be intended by the doer or cause to be known to be likely to cause to be known to the persons, which kind of for children below 12 years allows corporal punishment. Now that becomes a justification to going for corporal punishment even in the setup of schools. How do we ban corporal punishment with this kind of a provision in IPC? That's my question.
The panel, with the understanding that the questions that were not asked here will be asked to you during the break. And I'm sure I have everyone's agreement. So whoever did not get a chance now will get a chance during the break. I will start perhaps with you, Niranjan. Would you quickly respond to some of the questions?
Thank you very much for raising very important questions. And just to talk about the reference made by Upendra Bakshi, yes, there was a judgment in 2015, single bench, but that was contested. I think probably we have to understand the whole, kind of the issue of education. Probably why the middle class, the upper middle class, they are escaping from the, kind of government school is basically, like, we in a way, we lost, kind of confidence in, those schools. So how do we bring back it? I think probably the only solution that is available, whether we can transform each government school into a genuine neighborhood school is the real challenge before all of us. How do we do that? I think probably this can be, there is no dearth for examples. If you look at the examples in the country, even today, the best schools in the country are not private schools. I just want to underline this. The best schools in the country are the schools run by the central government. So the simple solution, if the central government schools are the best schools, why can't we upgrade or why can't we make all government schools on par with the central school is a very simple, kind of a solution that we can think of. And certainly, I think this will address the issue raised by the, Shanta Sinha. Like today, the kind of increasing privatization. It is not just privatization, but it is also discrimination, segregation. And we have in this country 8 different types of schools. Schools affiliated to IB International Baccalaureate, Oxford, Cambridge, ICSE, CBSE, aided. I think probably even Britishers have not divided this country on these lines. This is really appalling, appalling. And how can you build a kind of a egalitarian nation with social justice and equity with this kind of segregation and discrimination? Probably, I think we need to debate more because of the time constraint. I may not be able to answer all these questions, but one thing is very sure. Unless we build a strong education system, all our aspirations from last 3 days, transforming the society, using, kind of different tools for transforming the entire socio-economic and political transformation is just impossible. That is what my understanding. Thank you very much.
Thank you. Anita, can I give you the floor?
One is the same thing about children are not failed but moved up, what to do. Walter saying, isn't there an alternative? Not having exams. The right to education does not say no exams. This is a myth that is being propagated. It says exams and CCE, continuous comprehensive assessment. And we have models for that. We have states which have done it. Kerala had some of the best exam renewal systems, which it did 15 years back. And we know what it did, how children participated, learnt much better, and performed amazing things which even children in 9th and 10th can't be doing. So we have those things. It's just that they're not being done and a myth is being propagated. So the 25% alternative, Walter again said, no. This was not to allow poor children to get good quality education. It was not that. It's a misinterpretation. It was to allow privileged children to get quality social realities and understanding of that and democracy in their schools. Very clearly the Act had said, and the court reiterated when it was challenged. It has a beautiful statement which said, private schools must give 25% seats to the poor for the sake of establishing, maintaining the social fabric of democracy. So it is a myth when we spread this that poor children are being sent to private schools and government doesn't bother about them. So, lastly, about corporal punishment, it is this, you should tell us what you do when there are 2 clauses in 2 different acts, but it clearly says up to age 14 you will not. There is pressure. Certainly, once you don't do this with age 14, there can be we haven't had enough of work and orientation with teachers. Teachers were, in the Act it says they have to give special training to children who might come into a class at an older age. But they were never given that training. So they just look down on those children. Teachers were supposed to understand what is traditional knowledge. Don't alienate a child from his traditional knowledge, as we heard in the last section. But there's never this orientation, even though the curriculum framework talks about it. Thank you.
Thank you, Anita. Ashok?
Hello. Hello to Jatiya. So they have to send their children to the public schools, means government schools. Only then the schools will improve. I fully in agreement with that. But I personally feel that it can be a law only when central government makes a law about this. This is possible. It is possible. Second is about 25%. Of course, 25% alone is not a solution. We have to improve our government school system. It was only an idea to fill up the gap between rich and the poor and to hit the rich also that one way. We have to, as Niranjan has said, that all government schools in the country should be upgraded to the level of at least Kendriya Vidyalaya. If it is done, I think a lot of things will change. And finally, about Section 89 of IPC, I think the provisions of Juvenile Justice Act and the Right to Education Act will have the overriding effect on this. After the Right to Education Act has come, I have not seen any judgment on 89, Section 89. This is what my personal...
IT does not make corporal punishment an offense.
But it will have, we're reading with Juvenile Justice Act.
It does not have a provision for corporal.
There were judgments which went against 89, Section 89.
It's a punishable in accordance with the service rules. It's very clear. Section 7, those ones violating 7.
Okay, I think that one sentence I had said what courts can do and can't do was kind of, I think, evoked much more interest. But I would sort of take on the point which Professor Lipton and Professor Bakshi made in different kinds of ways, but said something similar. See, the point I was trying to make was, when you take something to court, you in effect say that they will be the arbiters of how this particular issue that is bothering you will get resolved. Whichever way it goes, it may go for you, it may go against you. It may be in consonance with your particular ideology, it may be against it. You have to, that's the inherent way of when you go to the courts. So we need to be very clear when we are going there that either decision is in some manner acceptable. If it is not, and if it's a kind of decision where greater kind of negotiation is required, where we need to, as people, keep that driving force in our own hands, I do not think it's a very wise decision to go to court. I do not know whether you were there, Justice Shakdar, but if you were not there, I do want to be sort of emphasizing it in your presence, that this business of being learned, good. I want to be sure. I want to be sure. No, my issue is, it's very fundamental. See, the thing is, you're constantly confronted with this kind of situation where courts are expected to be learned, not just in the law, but in everything else. And that's exactly the reason where one runs into trouble, that you go with decisions to, or you go with questions or issues to courts for which they are not the people who are the best kind of resolvers of it, then you run into all manner of difficulties. When I was highlighting the entire issue of justiciability, it is like it's a complex kind of argument. One was trying to keep to time and yet do all of that. What I was just trying to stress upon is that there will be times and there are things on which we have to go to court. For me, David, it would be all issues of very evident discrimination. Kinds of situations wherein you've nothing else left. You can't talk with people. You're faced up with a situation where you're just being stonewalled out. And there is no possibility of conversations. So the way in which, say, the untouchability question, Dalit education, minority this thing, the way in which girls' education is being addressed in a number of schools, and you have social practices which are legitimizing it. At that point of time, for me to go and negotiate and talk is stupid. That is a time where I need to go to a court and say, this is what my right is. You jolly well say it nice and strong. And it's extremely important that at that point of time, they say it nice and strong, right? But other than that, I wouldn't go there straight. I would definitely still want to do the negotiating thing. And unfortunately, Niranjan decided to speak about his own experiment in that half a minute of his 2 minutes, whereas I was hoping he would speak for 20 minutes on it. And it's a marvelous experiment of an individual who's gone to a panchayat, gone to a district, literally speaking, got people there galvanized in relation to the powers that they have under a school management committee. You have taken, as people, there are little things which are given to us under legislations. Instead of appropriating in our own powers, we expropriate them and give them to courts and ask them to resolve things for us. I do not think that's the way to go. That's the reason why I'm trying to problematize justiciability. On the side, I might be also having pot shots at courts, but that was not the central argument.
Well, thank you very much, first of all, to the panelists and then to the public. And I'm very sorry I could not give all of you the floor, but there is this commitment from all panelists. They will be more than happy to continue to respond to your questions in the tea break. Thank you very much.
Education panel, so they will be continuing it.
Okay.